resolution for the Harrison County Board of Education. We can forego the pledge to our later meeting, and we'll go ahead and open up and training session.
There's only one meeting.
Okay.
Okay.
Is there one tomorrow night?
Tomorrow night. Tomorrow night.
We'll get the pledge twice tomorrow night.
It's at 3 o'clock.
No, it isn't.
I was asked to come and visit with you about two things tonight, and try to make it efficient and get out of here at a recent hour for you. I'm willing to stay all night. I love this stuff. But first, just a reminder about the roles of board members. And you're not the only ones doing this. This slideshow I have here, it's a very short one. It's essentially one I've recently used with another board. It just felt like, you'd be doing everything right, you get down the road, you just want to go back and check fundamentals from time to time. And sometimes we find that we just innocently, without realizing, stray a little bit outside the lines, get back in and move on. And that's the spirit I'm here with tonight. I have an advantage. None of you can accuse me of kind of talking about something you did without using your name, because I don't know what you did, okay? So don't think that I'm zeroing in on anybody. I have no secret agenda because I don't know what you do. It's been a while since I've been here on a regular basis, and tonight that's good because I don't want anybody to take any of this personally. Everything I tell you, you may all have perfect legal hygiene on all this stuff, and you just go home and say, we're doing everything right. But if it does remind you about anything that you need to shape up a little bit, that's my purpose in doing that. Second, I want to give you just a sense of what the legislature did at its recent session. I understand you all weren't at the School Board Association training. It took 4.5 hours to go through the legislation with them. I'm going to try to reduce it to less than an hour here. And I'll give you some hints as to how we're doing that. But I just thank you for having me, and let's jump right into it. When I was in law school, your first year of law school, you take all these basic courses that have been taught the same way forever. And one of those classes is contracts. And as you would guess, you come to class and the professor teaches you what is a contract. It has to have two parties, has to have consideration, has to have signatures, has to have a date. How do you legally form a contract? And they talk about negotiations and drafting it and special things you put in it and all this. That takes almost the whole semester. And at the very end, they have a little section on, here's all the stuff you do if a contract's been breached. You can do this, you can do this, you can sue somebody for this, here's a defense. And you kind of just, it blows past you. Kind of like in history in high school. You get up to like the beginning of the Second World War and it's testing time and we go home. We don't learn what happened after that. Well, the year I went, this professor said, I'm going to start at the other end. I'm going to show you what can happen if you don't have a proper contract. And then I'll tell you how to have a proper contract and what's in it, but let's talk about the consequences. And I thought of that when I visited with this other board. We need to be reminded from time to time of, what's the, so what if we did something that technically we shouldn't have done? What's the problem? Well, recently you've seen the headlines. We talked a little bit about this before you got here, Frank, about the state intervening in several other counties. I've read the reports. They have an investigation report for Tyler County. They have an investigation report for Mingo County. They have one for Nicholas County. They have one for Logan County. And every single one of them cites the reasons that they're taking over. And there are all kinds of different reasons. But in every one of them are things about board members' behavior, board members following their own policies, board members stepping outside the lines. And I thought, maybe those board members, I know some of those people. They seem like God-fearing, law-abiding citizens. I wonder if it was an innocent straying from the path. So I thought I would show them, I'll show you too, and remind you. Of course, the biggest thing you can get are legal, not the biggest, but one thing is legal proceedings. Somebody comes in, you've had that happen. Somebody sued the school board claiming that the board did or didn't do something. You get hearings you have during personnel season, you have disciplinary hearings, you have student expulsion hearings, and other things. And every once in a while, somebody throws a flag and goes to see a lawyer and sues you. And of course, in the court action, the court can nullify the action that you took. That Open Meetings Act is a good example. If you make some decision as a board, and you know this, and it violates the way you did it, violates the open meetings law, and somebody goes to court, the law says the judge can erase what you did, can just rescind it, as if you never did it. And that can be disastrous. You get past personnel season and all your risks get rescinded and you're past the deadline to go back and do it over. Now you got this huge budget problem the next year. We had one school district that went through the excruciating process that you've been, maybe all of you have been through, trying to close a school. And the emotional public hearings, all the information you have to prepare, all the steps you have to take. They actually closed the school, removed the kitchen equipment and all the furniture, and in August, a court action finally came to decision and found that the night the board members voted to close the school, they violated the open meetings law and said, okay, here it is, August 15th, school starts next week, get that school back open, redo all your bus routes, so you can get kids back and forth, put people back in the building. You can imagine the mess that was just to get physically, to get everything back up and running. And then employees saying, you can't move me, it's past personnel season. It's a mess. So to me, that's almost the death penalty for a lawsuit if a judge wipes out some action you took. And then you're left like, what do we do now? Sometimes there's nothing you can do. You just have to eat the budget deficit or whatever it is. There's monetary liability too. Now you have insurance that covers most of the personal injury cases that are brought against the board. Every board has them. Somebody gets hurt on the playground or something else happens that injures somebody. And sometimes those go to court, but you're covered by insurance there. You're not covered by insurance in some types of lawsuits that can be brought. If somebody were to sue the board claiming that they weren't properly compensated, for example, or the board rejected the superintendent's recommendation for someone to fill a vacancy and forced the superintendent to recommend someone else, that person got it. The first person brings a lawsuit and said the board should not have rejected the superintendent's recommendation, and they find some irregularity, then they can get instated in a position with back pay and interest for the period they would have been there. I think the loss of public trust is a big one. You know, you can see just from the media publicity that last week's state board actions taking over those counties have generated, that the public really latches on to any stories about what they believe is misconduct or breach of the law or of trust by the Board of Education or the superintendent or the principals or whoever it is. And that isn't easily repaired. Sometimes that follows you around the rest of your career. Sometimes it ends your career. So I always think that the public trust is so important. We want the public to know that we try to follow the law. And where we're found not to have, it was an innocent mistake. It wasn't a case of ignoring something that we knew we should or shouldn't do, or operating in the dark zone out here, illegal meetings or things of that sort. It can damage your reputation too. We have some, would you like to be the Nicholas County Superintendent? Got fired last week. He found out about it when we did. I was watching the state board meeting online. He didn't know he was going to be fired. They fired him effective 4 p.m. that day. It's public. Everybody knows about it in the education community. What do you think his chances are of getting hired someplace else as an administrator? State board intervention is really big right now. We're talking, there are 5 counties that are total intervention right now. There are 2 that are under close watch by the State Department. There are rumors that a couple more may be taken over. That's sort of the ultimate penalty. I've been asked by the state board to come in and be the attorney for the school system after it's taken over in several counties. When the state board appointed a new superintendent, and the board meetings you wouldn't recognize them. Board members have no powers in those counties, but they have to come to the meetings or else they can be let go for willful neglect of duty. They come in, the board president calls the meeting to order, they say the pledge, and they are asked to approve the minutes of the last meeting. And then they turn to the state appointed superintendent, say, tell us what decisions you all have made. They go down, they have lists, just like your personnel agendas, all the transfers, all the hirings, all that stuff, approve all the financial items. There's no discussion on the board. The board just sits there. If there are delegations, the board members aren't allowed to speak. They have no power. And then when it's over, the meeting's adjourned and they go home. It's very difficult, especially for people who ran, in most cases, for the board, hoping that they'd make a difference. Then they find out it's even worse than not making a difference. They've just had to turn everything over to a well-intentioned person who sometimes comes from outside the county and doesn't feel the same way about the county that they do. Personal financial liability rarely happens, but it can. Fortunately, in most cases, if the school system is sued for something, you either have insurance or the board takes care of it. They oftentimes name the superintendent as a party in a lawsuit that really is against the board. Sometimes they'll name all the board members. In the end, you rarely are in a position where you have to worry about your own property or money being at risk, but it can happen. And the place it's happened in West Virginia is where there's a federal law that gives somebody a civil right. Special ed is a good example, the right to a free and appropriate education that is responsive to their disabling condition. And when parents go to federal court and prevail, the judge will order the school district to do something, maybe compensatory education, maybe some things like that, but always orders the school board to pay legal fees. And if they find that a particular board member or a particular principal or a superintendent purposely, knowingly violated the rights of the student under the idea, then the court has the ability to make the individual that was found to have intentionally violated the rules pay the attorney's fees of the other side, which today are in six figures in a case like that. We've had that in some First Amendment cases and some religion cases too in schools where an outside organization has come in, or the ACLU, for example, and represented somebody going against a public entity in West Virginia claiming that they're violating their clients' rights to freedom of religion or freedom of speech. And those are federal rights. And so if a federal court finds that there was a violation, they may not find that the person's entitled to any damages for injuries, but they may assess all the attorney's fees against the other side. And if they find that a particular individual on the school board side intentionally caused this to happen, they can make them pay it themselves. Rarely happens. Criminal convictions, that almost sounds like the least of your worries after all that stuff. But by the way, it's a crime to violate the open meetings law. It's a misdemeanor. And if a person really wants to enforce those rights and is really upset by what they believe is a violation of the open meetings law, they can go out and swear out a criminal complaint against board members for having an illegal meeting or going into executive session without the proper procedure or for the wrong reasons or Lord knows what. Loss of certification. I don't know, some of you are former educators. If you still have a certificate or something, you can lose it in some litigation where it's shown that you willfully violated someone's rights. And you can be removed from office. Now, the only people that can remove you from office is a 3-judge circuit court. And that's after enough citizens have signed a petition asking that you be removed from office. So the state board when it takes over a county, you can't kick anybody off the school board. But it takes a certain number of citizens filing a petition with the circuit court, and the circuit court then sends that to the Supreme Court, and they appoint 3 circuit judges to conduct a trial to see whether, as these people allege, the board member either engaged in willful neglect of duty or was incompetent or engaged in misconduct that has to do with the duties of their job.
Is there a reason to go after the pledge, or can just anyone at any point in time go drum up signatures or try to drum up signatures?
Well, they can try to do that, but the statute, if you want to look at it, sometimes it's really brief. It's 6-6-7 of the West Virginia Code. And it just says official misconduct, willful neglect of duty, or incompetence. So someone could get a petition signed and present it to the court. The first thing the court's going to entertain is if a board member says, Your Honor, we don't think this petition is valid. It doesn't allege any misconduct, willful neglect of duty, or incompetence sufficient to warrant being removed. Even if everything they say is true what I did, it doesn't amount to that, so throw it out. So that's how they take care of situations where some citizens don't understand that you have to have grounds. You get a trial, and they have to put on evidence showing you did those things. They don't realize that. They just think if we present like other petitions, we just give it to somebody. And that goes nowhere if they haven't met those requirements. Okay? So I just want to remind you of those things, not to scare you, but I do think it's good just to remember that what we do up here and how we do it sometimes can, especially if someone latches on to you and is intent on getting some decision you may set aside, sometimes they don't limit their focus to just what you did at that meeting. They'll go look at other things you've done or other things they believe puts you in a position where you're outside the lines. Okay. Now, this is a little bit of a review. I've given you this little sheet here that I think you all would have received an orientation at some time. This is the version we turned into an article for the School Board Association back in 2022. Nothing of this has changed. And I'm not going to go through this point by point, but if you look at anything I give you here tonight, I'd suggest you get a quiet place sometime and go through this. Kind of examine your conscience, go down through here and say, oh, well, I'm not really operating that way, or I didn't really understand that, or I've forgotten that. The front are the rules of law. And if any of you have if you say, I want to see where it says that, let me know as a courtesy. I'll send you the court case or the statute or whatever. I can assure you that the rules of law, those 12 rules, are hard, fast rules of law in West Virginia. And the second page is words to the wise. This is our advice, practical advice to you on how to stay on the right side of those laws. And you might want to look at these too, just yourself. Examine your own understandings and beliefs and the way you operate. And you can't be protected against people who file, lawsuits that have no substance, that don't tell the truth when they file them, or file charges or try to remove you from office. But that's just going to happen. That's part of being a public official. But I would say if you honestly followed what's on these 2 pages, I would be shocked if you ever found yourself as a board member caught up in any of those consequences I just talked about. We've produced these with those things in mind. These are the areas, these are the directions that the texts come from. And so we've tried to give you practical advice on how to handle them. Again, I'm not going to go through that. You can read it yourself. But to remind you, at the orientation, we always tell you that school boards are corporations. You act as a corporation. You don't act as board members individually. And in the eyes of the law, school boards are the most limited powers of any corporation that the West Virginia laws allow to exist in West Virginia. You are really hamstrung. You know that all the time. Big things and little things. Sometimes people who aren't associated with the school district can't believe you when you tell them that you couldn't do something because the laws hamstring you. And even the language. You have a neighbor who's not in the school system, and you come home and they say, guess what, I got a new job. And you say, was it $240 job? What the heck are you talking about? We have our own language, right? We all know what that means. So we are unique. And the second point is, well, actually the bottom point, and it's number 1 on your handout. The school board can exercise only such power as is expressly conferred or fairly arises by necessary implication. And then even only in the mode prescribed or authorized by statute. We told you at the orientation that when somebody says, I'd like to do this, a fellow board member says, I think we should do this. You say, well, I don't think we can. And you say, well, where does it say we can't do? Where's the law that says we can't do this? And that happens in our own lives all the time, right? That's not a proper question for school boards. Absolutely irrelevant. The question should be, show me the law that says we can do this. You have to find a statute, legislation, or a policy of the state board that says you can do what you propose to do. And we have a dozen West Virginia Supreme Court cases over the years that have had problems with boards that said, well, there's no law that says we can't do it. And the Supreme Court has said, and that's their language there. No, you have to show me that you can do this, that you have authority to do this. Either it expressly says you can do it, or it expressly says you can do something, and you can't do that without doing something else they didn't mention. But once you get outside of that, you can't do it. That's why they're a limited corporation. As board members, you've got to limit your scope in that fashion. And the trick is to do all the good things you want to do for the school system by finding ways that you're authorized to do it in the school laws or in the policies, which is what I like to do. I like the positive side of school law, not the negative side. Now, I want to remind you that Another reason we have to be careful, based on this being a corporation, is this next line. A member of the board individually has no authority of any kind in connection with the schools, except for the president. And you can call a special meeting of the board all by your lonesome. Your name also appears on checks and things like that that are issued outside of a board meeting. At orientation, you may remember, if we were in Morgantown, we oriented Morgantown or Charleston? Charleston? Well, in Morgantown, we do this in Charleston, but it's more dramatic in Morgantown. They're always in this one room there, fill the room, they take a break, and we always say, when you come back, don't come back to your seats. There's a big outdoor walkway all across that room. It's big windows, and you see the river out there and the rails to trails they have out there. And I said, you go out there, and then they all come out there, and they're all lined up along this railing. It goes on forever. And then I tell them that we have a little surprise for them. Somebody is going to come walking up that trail right past here. I don't want you all to say a word. And it's somebody you know, or you may recognize, but don't tell anybody else if you recognize that person. And when you're done, let's come inside, and then I'll ask you if you know who that person is. And it's amazing, you know, they're all, oh, looking at this person. They come in and say, I think it was, somebody told me they thought it was Janet Reno, who used to be the Attorney General of the United States. So, somebody said it was Jennifer Gardner, who was down in Charleston last week, but back then was still popular. We had all kinds of guesses. And the answer was, that's a person just off the street who has as much right to do anything in the school system as you do as a school board member. It's a stranger. And they really were strangers. I just went out there and remember I've often wondered about those people. They go home and say, you don't believe what happened to me today. I was walking past this building. There were 100 people just looking at me like this, staring at me. But that's a real important message. And to me, and I saw this in the Mingo County report of the takeover, saw a little bit in the Logan County last year, this sense that school board members get so dedicated to what they're doing that they try to do it outside of a meeting. And you have no more authority outside of a meeting than that person walking up the rail to trail. Yeah, we at Canaan last year, we just called one of the waiters in from up the hall up there and says, anybody recognize this guy's wearing a waiter's uniform? And they all thought it was some trick. And it was just, he's a guy who has much business barging into schools or telling the superintendent, you're to do this, or telling the bus operator, you should do this, or investigating some complaint somebody has. Those people have no right to do that, and you don't either, which kind of hurts. You know, our congressman, Senator Capito's back talking to people, doing things, going back. But as elected officials, sometimes you think that's your right, but you have no right. And you get away with it until somebody throws the flag, and then you're really embarrassed and could be in trouble. So always remember this. You have no more power than the person on the street, unless you're here. You're at a meeting. The board, as a board decides to do something, that's a completely different thing, okay? This is another line that is often, you know, no, I don't have the slides for you. What slide number is this?
5.
Let's go back to 4 a minute, because I gave you some of your own board policies here. And take a look. Remember, we're going to talk in a minute. You have to follow your own policies. You can't say, well, that's just a policy. We don't have to follow this. It's the same as if the legislature passed it as a law until you change it. That's what the court said. And so while we're on this slide, I looked at the board policy 122.1. These are in order in your handout. The very first one. Board members as individuals do not separately possess the powers that reside in the Board of Education. Just because you're a board member doesn't mean you can, on your own, do things that the board can do, right? And then the next one I want to go to is just a few down. It's 148.1. It says board staff communication. See that policy? 148.1, board staff communication. Yes, sir. First line, the Board of Education is a policy-making body and its individual members do not have authority to direct the day-to-day operations of the district or its employees. That's your policy. That's the law in this county. And then it has some rules about how communications between the board and the public occur, and we'll talk about that here in a moment. If you just go right past that to policy 149, this is your policy. Individual members of the board do not possess the powers that reside in the corporate board of education. And then the big one, you wouldn't think this is a big thing, but it happens a lot, is way back toward the back, this policy 9150, school visitors. We had a board member in one county that rode a motorcycle instead of a car. The principals would know that he was in their building because he would ride his motorcycle right up into the lot, get parked around. And then a couple teachers would throw it up in their hands. It was very dramatic. And you can pre-in, but it's still wrong, you know. And here's your own policy, which we have to follow, 9150. And look down at the bottom, the third paragraph at the bottom. Individual board members who are interested in visiting schools, classrooms, or other facilities on an unofficial basis shall make the appropriate arrangements with the principal or building administrator. Such board member visits shall not be considered to be official unless designated as such by the board. So the board in a meeting can say, we hereby, I move that our board president go visit the career center and bring a report back to us as to whether blah, 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 blah. Okay, when the board president goes to the career center and does that, he's not going as an individual board member. He's going as a representative of the Board of Education. That's what this writing means here. The next paragraph, the board member shall be visiting as an interested individual in a similar capacity to any parent or citizen of the community. These visits should not be considered to be inspections, nor as supervisory in nature. And then the next one, if during a visit to a school or program, a board member observes a situation or condition that causes concern, she or he should discuss the situation with the superintendent as soon as convenient or appropriate. Now, the guy with the motorcycle was doing that all wrong. Nobody would be allowed to drive a motorcycle into the school because he's a board member. He had no special parking privileges in the lobby of the school. He wasn't stopping, like all visitors to the school, at the principal's office and following the rules, which we've had very strict rules about parents and others who want to visit classrooms. We allow it, but we have some strict rules. They're not to talk when they're in there. They're not to ask questions of the teacher. If it's a service person doing their job, they're not to say, why didn't you get that dust bunny out of the corner there? I saw you passed it up. None of that. If that's a concern, we go to the superintendent. But outside of that, they're just like me going into your school, or my wife going into the school. If they have a problem, we don't interrupt class. We don't chastise the principal as this guy with the motorcycle did, happened to do it. I go see the superintendent about the problem. Say, I was just in school, and I can't believe I thought her teacher used a bad word. And somebody spilled something in the classroom. I just wanted you to know that. Now, you can hold the superintendent accountable if you give the superintendent a report like that, and then next time you see the superintendent, you look into that, and she didn't, and you think she should have, that's on her. That's not on you, it's not on you, it's on her. But we as board members have no authority to do that. Okay, I want to call out just those policies that you have. Investigations are another thing. Of course, that has an extra danger in it. Not only do you not have authority to carry out an investigation, the private citizen couldn't come in and say, well, I understand so-and-so was bullied. I want to talk to that boy who supposedly said this to them. And I want to, well, look, the citizen can't do that. You can't either. And if you do it, now you create a problem for the whole board. Because if there's a hearing to expel a student from school or suspend an employee for something like that, if they can show that a board member on their own went to the school or went to somebody's home or called somebody's mother to talk about this, they may have a valid claim to have any discipline thrown out the window because their due process was violated. The law says that when somebody has a hearing in front of the board has to base its decision on what happened at the hearing and nothing else. So if there's a board member, I went out and called the kid's mother and said, did this really happen? Now I'm coming to the board meeting, I can't forget what she told me. And so now, if we discipline the employer, discipline the student, they can claim their due process rights were violated because at least one board member, who knows who they told, had it in their head and couldn't forget what they heard from that mother when they cast their vote on the students or the employees' discipline.
Doesn't that also apply to hearings?
Yeah.
Employee hearings as well?
Yeah, employee hearings, personnel season, we're going to cut Howard's assistant principal job at the high school as part of reduction of force. If Howard's got some arguments to make opposing that, they should be made right here at the hearing. And he tries to whisper in your ear as a board member, "Oh, they're going to, please don't want to do this. You can't believe they're doing this. They're just doing this." Don't listen. Tell them I can't listen to that. If I do, there could be legal trouble for all of us. And don't listen to the administrators who might come to you and say, well, the superintendent's recommended this, and we need to get rid of that person. He's a bad apple. Just think of that. Why would the law say that somebody can come before you for a hearing and present evidence and you make a decision if they didn't mean for it to be like in court? If this were a criminal case and you were on a jury, you couldn't go out and go to the murder scene all by yourself at night before you come back into court the next day. If they found out you did that and somebody was convicted, their conviction would probably be overturned. I just want to be very careful. And I think it's protection for you in a way. You're not having to devote time to investigating things. And you can say to people on either side of the case that want to get your attention, I know they always do, I'd love to listen to you, but we've heard that if I listen to this, it may jeopardize whatever we do in the end. And so I'd love to listen to you. The lawyer told us that there are court cases out there that find that to be a violation of the person's constitutional rights.
Yeah, I got a question, maybe it's not exactly right here, but let's say a position is available, okay? We as board members, maybe we get a call, say, hey, we hear you got a position coming up in your county or whatever. And so at that point, we would say, it's a possibility that you need to talk to the superintendent about that.
Unless it's been posted, then it's public information. You can say, yeah, there's a posting right now. I just looked online. There's a posting right now. You ought to look at it yourself and blah, blah, blah. That's okay. It's public information. Because I could do that as a citizen. If my cousin called me from Nebraska and said, are there any openings in the Harrison County schools? Well, yeah, I'm looking here online. Yeah, there's strict chiefing jobs you could qualify for here. Yeah.
Okay, so, but is, this person say, well, I'm interested in a position, we as an individual board member, we cannot meet with them
No.
or talk to them.
No.
Then that's a
If
violation.
you do, and somebody doesn't get the job and finds out that you talked to them,
Oh.
I've been in grievances where this has been the issue. Someone says, well, I happen to know that so-and-so who got this job talked to board member so-and-so, and and they file grievances, and they go, for the next 6 months, you're going to hearings. And so just think, there's that old thing, what would Jesus do? And just think, what would the man on the street do if they were faced with the concern that I am? Would they be allowed to go in and make the principal answer their questions or show them someone's personnel file or listen to somebody try to persuade me that they should get the job? Because I'm just a person on the street. I can't.
So it should come down to the superintendent, in other words, their recommendation.
Yeah.
Okay, so we as an individual board member, all we can say is there's a job available, you have to check in.
If it's public information, as that might be if it were posted, or that maybe the minutes of the board that released that are now available say the board's going to create a position for next year, that anybody can access that. But you just need to think, you're the ultimate decision maker in a lot of cases. So you got to be very careful about what happens before you make that decision. Now, I'm going to skip ahead here a little bit in the interest of time. But I said this before, I'm going to say it again. There are grievance board decisions. There are human rights decisions. There are court decisions. Say over and over again, if you have something in your policy manual, it's a current policy, you must follow it unless it violates the Constitution or some statute that the legislature's passed. So if you've got an illegal policy, then you can't say, well, I'm supposed to follow our board policy, so I couldn't help it, it's illegal. No, if it's illegal, where they rarely are, you've got those Neola policies, and they have lawyers look at them and everything. But if it's an illegal policy, then you don't have to follow it. In all of the cases, you do until it's changed. And of course, there's a process for changing a policy. You can't just say at a board meeting, I move that for tonight's purposes, we waive our policy that says blah, blah, blah. No, you have a policy on policies. It talks about a first reading and a second reading and public input and all. So follow your policies. And there are cases and decisions and make it very clear that if you don't, and again, that's shown up in these reports that the State Department has before they took over counties. Things that the most recent one is the Tyler County situation. There's like half a dozen findings in there that cite particular education policies in Tyler County that they claim the board did not follow in various matters that they handled. So they're paying attention to those things. It's not an esoteric thing like you might sometimes think. So that's why I've given you this slug of policies, and we can't go through all of them, and this isn't all of them, but these are the ones that I thought when you're talking about the role of a board of education, you want to pay some attention to, because they talk about the superintendent's relations to the board, who communicates things to the public, and I'll mention a few of those here in just a moment. I want to give you, and again, I tried to bring some handouts so you could read them outside of here, and not have to take the time here, but these are actual quotes from State Superintendent of Schools interpretations, which also have the source of law, about this issue we're talking about board members. You can pass those around if you want. Board members not having powers outside the board meeting. It talks about looking at student records, looking at personnel records, whether you can have an office here at the board, whether you can have an office here at the board and see visitors, whether you can investigate things, whether you can tell principals and other employees what to do. This is verbatim. I just took these out of different state superintendent interpretations that are still in effect. And they fortify what I just told you. Now, this is really, I think, an important point that whether you're even if you're at a meeting, you as an individual board member have no authority to make somebody do something, give them an order. The whole board can vote on that. But you're sitting here in an open meeting and called to order, something's being discussed. I can't turn to the superintendent and say, by the next meeting, you will furnish us with blah, 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 blah. And you will go see such and such a principal and come back and tell us what you learned. The board didn't do that, I did it. And I don't have that authority even at a meeting to act as an individual. I can make a request. I can say, superintendent, would it be a problem for you to bring back some data on X, Y, Z at the next board meeting, put it on the agenda? And she says yes, then that's fine. Just like a citizen could say, could you give me information about disciplinary referrals in the county in the last year? If she says yes, then that's a courtesy, and as long as the students' names are not in there and so forth, it's okay. So you can make a request as an individual, but you can never make a demand. And if you make a demand and an employee doesn't follow it, including the superintendent, you cannot hold them accountable for that because it's an illegal demand. So you can't say, well, at evaluation time, I'm going to give the superintendent, I think we ought to give her a really low score. I'm working with the board. I went to her office and said, I wanted to see the personnel files of the employees who applied for this job, and she wouldn't give them to me. Can you believe that? Yeah, I can believe it because she has no business giving you the files. And you'll see that in one of the things that the state superintendent of schools wrote here. Your policy 9130 is toward the end of the bunch. I think we just looked at it for another reason a moment ago. This is about the people that come to you with, let's find it here. Yeah, with complaints. And you can read this about complaints about a professional staff member, complaints about a service person, complaints about this, complaints about that. At every turn, it says that if a person brings a complaint to a board member, they are to make the superintendent aware of it. And if it came to you in writing, like in an email or something, as a board member, your policy says you have to give a copy of it to all the other board members. Having done that, maybe there's nothing board or individual board members can do about it, but the superintendent gets it. And I don't want us to go through this policy line by line, but if you read it, you'll very clearly see that. And in fact, on the second page, midway down, and you see where it says fourth level there toward the top, D, fourth level. It goes down, the final paragraph in that section says, if the complainant contacts an individual board member to discuss the matter, the board member shall inform the complainant that she or he has no authority to act in his or her individual capacity, and that the complainant must follow the procedure described in this policy. And the procedure in this policy is that these complaints don't start with the Board of Education. They start, in most cases, at a low level and work their way up into the system. You could read that. But that's your own policy. This board has decided that that's the law in this county when it comes to complaints that are made about things. And you'll see back on the first page, under the very beginning, it's like the third paragraph. Any requests, suggestions, or complaints reaching the board, board members, and the administration shall be referred to the superintendent for consideration according to the following procedure. And this is to tell you that if you give a directive as an individual board member to an employee, if they don't do it, they cannot be held accountable for that. That's not insubordination. Because if there is insubordination, somebody has to give you an order that you have a right to do, then you have to disobey it. Okay? So, and think about this. You're the janitor, and I'm the board member, and I come in and say, I don't care if you've got time to do this or not. I want you to go out there and get that mess out of the front of the building. Are you going to say, I'm not going to do that? You can't tell me to do that. No, that's what's bad about individual board members doing things. You're my ultimate boss. Scares the heck out of me that a board member told me to go out there and clean that mess up. You know, board member told me about walking hot coals. I might do it to keep my job, right? But just because a person capitulates and does something they would never do to a person off the street, doesn't make it right. But think about that power relationship. You've got employees that are scared to death. And it's not just the janitors or the bus operators, it's administrators, it's people throughout the system, because they may say, well, she doesn't have the right to tell me that, or he doesn't have the right to tell me that, but how do I know when personnel season comes along, or the next time I apply for a job or something like that, that it won't, nothing will be said, but don't get even with me for this. So this is just, the board itself can issue and expect compliance with directives and orders only if the board is authorized by law to make the directive, complies with any conditions or procedures imposed by law, complies with any applicable board policies, and takes the action at a duly called board meeting under an agenda item that reasonably apprises the public that such action may be taken at the meeting. And I see this in several decisions. The board itself should ordinarily not even take that step of to say, I move that we order the assistant principal of that school to quit parking when they're parking at that school. I didn't have a place to park when I went there. You know, even the board should not be directing particular employees to do anything. Your direction is to the superintendent. I move that the superintendent resolve the problem with the parking space at the school where I want to park. There's some employee parking there. Your directives are to the superintendent, and then you judge the superintendent on his or her follow through. Okay.
I like to be able to park in the law when I come.
On these motorcycles.
Yeah, you're gonna get a motorcycle.
And I've cited some board policies here. Your board policy 148.1, and you got these slides so you can see, you can read these statements and see the policy that I've cited of yours that follows it. That one in the middle says you can't even discuss, much less decide a matter that is raised by delegations at your board meetings. You can't do it at that meeting unless it's on the agenda. The most you can do is to say, I move this, if you want to, I move that we place this on the agenda of a future meeting, and you can pass that. I brought you many of you know Mr. Crawford on the Kanawha County Board. He's been around for a long time. He got really concerned about how they were dealing with delegation. recommendations. He wrote to the Ethics Commission, which by law has to give opinions on things like meeting procedure. He passed that out. This is the Ethics Commission's advice on that issue, and their advice is something we follow. But it goes around the horn, but it basically says what I just said, that if delegation raises something, you can't discuss the merits of it. You can't ask enough questions. You might not understand what they're saying. They say, we got to get a new roof on that school, it's leaking. You're allowed to say, well, what school are you talking about? Enough information, you don't have judgment on it. Enough information that you know what you're talking about, so you can put it on the agenda and then go into it. And if the board's policies require you to follow Robert's rules, then you must. Mingo County, in the report that was released last week, was found to have violated Robert's rules of order on several important decisions they made. And Robert's rules let you be quite, even the Robert's rules say that small groups like yours can be a little informal in the way it does things, but there are still some rules that have to be followed. I'm giving you the policy of yours that says we follow Robert's rules. And then one sore spot is board members talking outside of board meetings when people think you're talking to the board. That's probably not a problem here, but in some boards, we'll have somebody go out there and say, well, we had a meeting, we discussed this, or maybe we discussed it in the executive session, but I want you to know that this board will stand behind so-and-so no matter what, or we're going to do this. If the board hasn't decided to do those things, that's a dangerous thing for someone to do. And so the best advice is that boards have a policy that designates somebody as their official spokesperson, and that all the other board members have a right to express their opinions on things, but they have to go out of their way to make it clear to whoever they're talking to, the news media, a neighbor, whatever, this is my opinion. This is not the board's opinion. This is my personal opinion. You can do that when you're campaigning. You can do that when you're talking to somebody. And I've given you a citation to your own board policy that outlines all the steps you're supposed to take. Now, you've designated your board president as your official spokesperson in your policy. And so the president doesn't have to stop and ask the rest of you if he can talk about something that happened. Of course, he has to be truthful. The rest of you be very careful, because even on social media, you'll have people that'll say something on social media about, I can't believe that other people on the board did this. Here's what the board needs to do, and here's what I'm going to see that they do. You can't do that, but you're speaking for the board. But you can express your own opinion. I voted against the bond issue for the following reasons. That's fine. You're talking about your own opinion, but you're not saying anything about the board's position. And in really controversial times when opinions are heated, that's when this becomes a major concern. People hear what they want to hear from individual board members. Well, Mr. So-and-so promised me I'd get this job based on the people that applied. He knew who had applied. He said the board would surely hire me, and I didn't get the job. I've had to defend that, and it's hard to defend in grievances filed by unsuccessful applicants for jobs. I just remind you, and you can, again, read your own policies. On the ethics deck, you've got a policy 6460 and policy 141.2. 6460 and 141.2. Just to refresh your understanding of staying away from situations where you may have a conflict of interest. I found that people call me all the time and say, I'm wondering if it would be a problem if my daughter's ex-husband has a business and they bid on such and such work for the board. Do I have to recuse myself from the vote or the board even enter into that contract? And we'll talk about it. I've learned that that can call means that they knew there was something, probably something didn't smell right. And that's the test.
You didn't pass the smell test.
If you find yourself in that situation where, I know the superintendent's recommending we hire his step-grandson, and I know he's a sex offender. Is that a problem? No. Some things just don't, especially when it gets close to you, when it's your close relatives or people you work with, it might not be a problem. But rather than try to remember all the rules as to when it's a problem and when it isn't, some of those are in the policy there. That's when you ask a question. And I'll tell you, there's one, the Ethics Commission in Charleston as an office, and one of their main jobs is to give people advice about whether something the board is going to do is an ethical problem for them, whether they have to stay out of it or whether the board has to stay out of it. The legislature's told them to take calls from people and give them advice. And I have never been put on hold there. I've never had to leave a voice message and have someone call me back. They almost always answer the question right there. Now, they might say, well, let me go find something here in our files or whatever. They are, in my opinion, the most responsive agency in state government. Never hesitate to call them. They're not allowed to go telling the world, well, Howard called, and you believe he might know if his brother could do both. They're not allowed to do that. And they'll give you oral advice, and they keep a record of it. So if later, someone doesn't believe that you checked and they said it was okay, they'll go back and say, yeah, we told him it was okay. That's a complete defense if somebody charges you with doing something wrong by voting on a matter like that, if the Ethics Commission told you. They'll even give you a written opinion if you want one. So and I'm giving you their phone number. I call them all the time. Some of you have been around long enough, you may remember the Service Personnel Association's attorney, John Roush, for many years. He's the staff member there that usually takes the calls about school board things because he understands school boards. He's been around.
You said 141.2, what was the second number you gave?
I gave you 6460. You may not have it,
Okay,
but if you don't, make a mark. And
64.
It's in the big binder.
And you can read this other slide. It talks to you about the same thing. It cites some of your own policies. And then finally, the superintendent's role as the CEO. I can tell you in 3 of the review reports of the State Department of counties they took over, there's criticism of the way the board and the superintendent related to each other. And in these cases, typically, it was the board not respecting the superintendent's prerogatives, which is why the state then took it over and sidelined the Board of Education. But sometimes they remove the superintendent too. There are things that you have said the superintendent has to do. Look at your policies, what's that, 1230, is that what's on the slide? Look at 1230. It's in this stack. Remember, this is a policy. You all have decided to do this. Is 1230 in there?
Yes.
Okay. Look at all that stuff. This is stuff you have said our superintendents to do.
Goes through the alphabet twice.
And even if you didn't have a policy that says, here's what our superintendent's to do, meaning the superintendent does it and you don't. Here are the state laws about what the superintendent's to do. And you can't take these powers away from your superintendent, even though you didn't intend to do it. Sometimes it looks like you did when you ignore this. These are 3 statutes passed by the legislature that say, we don't care what your board says. As a legislature, we're telling you this is what your superintendent's powers and responsibilities are. And I'm going to close this off with having you look at 2 of your board policies, or mark them to look at them on your own. And one is policy 1210. I mentioned it before. Let's look at 1210 real quick.
Board superintendent relationship.
Yeah. Look at that first line. People say, what's the board supposed to do? What's the superintendent supposed to do? The Board of Education of the school system believes that in general, it is the primary duty of the board to establish policies and that of the superintendent to administer such policies. Policy should not be originated or changed without a recommendation of the superintendent. The last sentence in that paragraph, the superintendent should be given the latitude to determine the best method of implementing the policies of the board. And then in the next paragraph, the superintendent, as the chief executive officer of the county school system, is the primary professional advisor to the board. She or he is responsible for the development, supervision, and operation of the school program and facilities. The next paragraph, the board shall retain oversight supervision of such procedures. And then the last paragraph says, if you've got a problem with how the superintendent's doing it, reflect it in the annual evaluation that by law you're supposed to do. And then the other policy I really like in here, and this is the one to read at home, is right at the beginning, policy 123. The code of ethics that you have passed as a policy, or your board has, whereby serving on this board, you agree to abide by all the elements of that code. Go in that quiet room, and you got that first handout I gave you, look at the code, and give yourself a rating of 1 to 10 on each element of the code of ethics. Be honest with yourself. You don't have to tell anybody else. And you get some sense of where you stand with respect to your role as a Board of Education. And one other thing you've seen before, but occasionally we get a question. Your own policy says you take action based on the superintendent's recommendation. By law, there are certain things you cannot do without a superintendent's recommendation. And there are some things you can do, unless you have a policy saying you're still going to require the superintendent to make a recommendation. Your policy saying this is what the law requires. And some people are surprised. You can pass a budget without the superintendent's recommendation, unless you have a board policy that says we won't take action without the superintendent's recommendation. But on most personnel matters, you cannot. And you don't have to have the superintendent's recommendation on whether to give a superintendent contract.
You don't need her recommendation.
So that's what I have prepared for this first part. And if you've got any questions, I'll take a few, but I might really give you this new legislation and not take it too late. So we can switch the show to the other.
You know, sometimes I feel like I lost all of our weeds.
Now, let me tell you what we're going to do next. I told you it took 4.5 hours for me to go through these laws at the School Board Association meeting. We're going to take 4.5 hours tonight. In 2 weeks, we're going to be sending to everybody on our mailing list, that includes the superintendent, probably a bunch of you, and I'll show you how to get on the list if you're not. A publication we do every year. And that is, we wait till the smoke is cleared in the legislature, wait till the governor's vetoed or signed all the bills, which happened last week. We put them under an electron microscope, and we find every change that's been made, everything added, everything taken away, everything moved, every punctuation mark. And then we try objectively looking at that, not based on what the media told us about what the legislature did. We draft a summary with you all in mind of what the legislature did. And we send that out. Most years that runs 20 to 25 pages. This year it was 52 pages. So I'm not saying they made momentous changes to the school system. They just took a lot of time, a lot of room to do what they did. So we'll send that out. But I thought you might be interested in seeing some of the details before we get it. So on the PowerPoint we did for the School Board Association meeting, put a lot of information on the slides. I'm not going to cover it here. I'll just show you some highlights. That if you hear about a law, that hear when I'm talking, you want to know more about it, read the PowerPoint fine print. And then you'll get the full thing when we send it out in a couple of weeks. We have a seminar, all-day workshop Wednesday of this week, and Tuesday of the following week, and I think Monday of the following week, where we spend a whole day going over this with people in our offices. That's when we release the 50-some page document.
Oh, wow.
Yeah. That's it, that's all of them. I made a little list list here are the ones that want to say a few words about. You can read about the rest yourself. But before we get into it, my colleagues, somebody said, why did you bring them along with you? They're all trapped. But they should be free now by the cycling competition in Charleston. All the streets around our office are closed. If you didn't get there by 7 o'clock, you couldn't drive out today. So none of them came with me. But you see them at the conferences and things. And we're all part of the same team. Sometimes we should do what we want to say. Here's what I say. If you're not on our list, you can get on our mailing list for our newsletter called the e-newsletter. It doesn't charge, we don't charge anything. We try not to send it to just everybody in the world because there are people that would go through it looking for fights that can pick the school boards. We send them to school board members, administrators, legislators, things like that. It comes out quarterly. We try to send you just a note, alert you to recent court decisions and acts by the legislature and so forth. If you're on that list, you'll get this mailing in a couple of weeks. It's called the e-newsletter. You can get off the list at any time. We never use that list for anything else. And when you do get the quarterly newsletter, even up above that title there, it says, don't send this to me anymore. You click it, you don't get it. Don't you hate having to look for that unsubscribe thing at the bottom? So I'll tell you how to get on that list. We also have a podcast, the only one on West Virginia school law, that Trey Marone, my partner, is the host. And he covers the really timely things. He got the whole classification system on the SSAC with David Price. One of the laws I'm going to talk about here are going to require that risk assessments be done for misbehaving students. He had 2 podcasts with specialists in the risk assessments, what they are, how they're conducted, what they're worth. We have one on the marijuana laws, medical cannabis, and what do you do if somebody works for you but has a Pennsylvania prescription and brings it to school? And a lot of people listen to those. They're about 30 minutes long. And if you'd like to be alerted when a new one goes online, also ask to be put on the podcast list, and we'll send you one every time one comes out. They're also on our website. And then the workshop I was talking about, the all-day workshops we have called the Signature Series that are on different topics. They're by invitation only. If you want to get an invitation, in case you're interested, or you want to send somebody from the school system, you can get on that list too. The upcoming Signature Series, we have one on, well, the new legislation's coming up. We have a boot camp for people that want to know more about school personnel law, and that's a day and a half. We have one in the fall on employee discipline. It's been a while since we had one, and the rules have changed a little bit in recent years. And then at the end of the year, every year, we have rifts and transfers and all that personnel season stuff. So we'll alert you to those, and we'll send you an invitation if you're interested. To get on any of those lists, you need to send an email to Sarah Plants, and that information's on the slide you have. She's our assistant. Tell her who you are and with what board. That's how we try to screen it out, not just send it to troublemakers. I know they get a hold of it. I want to make it hard for them to get a hold of it. And if you say, I'd like to be on the newsletter list, she will send you a reply and have the last newsletter attached to it. And it'll be on the list going forward. If you want to be on the podcast list, she'll send you a link to the last podcast. And if you want to be on the Signature Series invitation list, she'll be sure that you get those invitations. Here's some bills that didn't pass. I'm going to go real fast here. But sometimes people think they did pass because you saw all this stuff in the news media when they were before the legislature. The immunization exemption, I think we all know the legislature defeated the effort to grant a religious or philosophical exemption to parents that didn't want to have their kids immunized, so that didn't pass. There was a bill to have locality pay for teachers, so the teachers in especially the border areas, in the Eastern Panhandle, those teachers, we would pay teachers more here in West Virginia than we might pay a teacher in Southern West Virginia. Just to be competitive, that didn't pass. No raises for teachers passed of any kind. There was one to start training athletic trainers in the secondary schools as part of CTE, and then have them finish that education in community and technical college for a year or two after they got out, because I guess there's a dire shortage of athletic trainers. That didn't pass. There was one that was going to require all elementary school teachers to be certified in the science of reading. That didn't pass. And there was another one that would have allowed middle or high school students to participate in travel sports teams. without repercussions. As you know, under the SSAC rules, there's some limitations on your students, athletes' ability to be on travel sports teams. That didn't pass. You know, they just make it easier and easier to leave the public schools. This one was going to give a parent a tax credit, dollar for dollar, for each student that they homeschooled in their home. And the tax credit would be equal to the amount of the Hope Scholarship. So if you had 2 children you homeschooled, you could get a tax credit of $6,000 or whatever the Hope Scholarship is now for each of those children. But it differs from the Hope Scholarship. Because, you know, the Hope Scholarship, the parents never get the money. You write to the treasurer and say, I want to get a laptop for my child. The treasurer pays for it to the vendor. I want to send my child to France to learn French. The treasurer takes care of it. Tax credit comes right off the person's taxes. So if you owe $6,000 in taxes, you'll get a $6,000 credit for your child. You not owe any taxes. And if you don't have any income, you can claim the $6,000 credit and get cash. So that's interesting. It didn't pass, but they would even think of something like that. There was a bill about equalizing the sizes of K, first, second, third grade classes, so that you didn't have to worry. People were supposedly sizing the classes to make it less costly to furnish the aid to every classroom that you're supposed to. If there's over 10 kids or whatever it is. That didn't pass. There was one that was going to make every administrative employee of every county board of education a will and pleasure employee who could be fired at any time for any reason or no reason. That didn't pass. There was one to start a pilot project with 3 adjacent counties for the State Board of Education to smush them together with one governing entity. That didn't pass. And then there was one, yes.
So if they would have passed that, just asking for mistake about the employees, taking real pleasure, would they still have their right to due process?
Well, there really is no due process because we don't have to give you a reason. The due process is to be sure that, now, as a school, certainly if I thought about that, I might convince myself that they're entitled to due process because they may say, I think you're firing me for no legal reason. You know, when you're at will, you can be fired for any reason or no reason, but not a no legal reason. So maybe if I thought it through, I might say, well, yeah, if they want to have the hearing, they may claim this is racial discrimination or sexual discrimination or handicap discrimination or some illegal reason they're getting rid of me. And I can show it with evidence. So maybe I'd think that through. I don't know what the bill actually said. It probably didn't say anything about due process. And then there was one about transferring some responsibility for ACE classes to the community technical colleges, and that didn't pass either. Let's look at what did pass. I'm just going to highlight a few of the bills and suggest you, if you're interested, really read the bullet points underneath them. I put them in these categories, and the first one's governance, and this is one that applies most directly to you. Remember last year they passed a bill that enhanced the training requirements for school board members, and there was a technical defect in the way it went through the legislature, and it never became law. They fixed it this year. So now they still have the requirement that you have to go to orientation before you take your seat on the board if you're elected in May. They've added to the topics to be covered their fiscal management, as well as the topics that they've usually covered. Now, the State Board of Education is authorized by this law and already did under the existing law, passed a policy saying there are certain reasons that are good excuses for not coming to orientation. Death in the family, things like that, your own death. And this says that if you're not at orientation, you're elected in May, you're supposed to go to orientation before you took your seat on the board. And one of those reasons kept you from coming. You can take your seat on the board, but you have to go to a makeup session within 30 days afterward. And any board question often comes up, well, do I have to go to orientation every time I'm reelected? This says that if you were a board member on July 1 of 2025, which isn't here yet, but hopefully you all will still be on the board July 1 of 2025, then, and you serve continuously after that date, you never have to go to orientation again. You can, but you don't have to. In terms of the training hours, right now you have to get 7 a year. This increases it to 12. So you have to get 12 training hours a year. And there too, they've added fiscal management as one of the training topics that has to be covered. And some federal laws, IDEA and the Every Challenge Succeeds Act also have to be part of the training you get in those 12 hours. This is interesting. In addition to the 12 hours, the state superintendent can say, I think this particular board member, they'll name them, in this county really needs some more training than 12 hours. It's a specialized training to be successful. And the state superintendent can go to the state board and say, I'm recommending that Mr. Devano get 15 hours of additional training and blah, blah, blah. If the state board imposes that, then that becomes your obligation as a board member. If you don't do it, then it's local elected duty. And
How would that happen? Though? You have to contact the SBA or school association or?
well, I'm sure that it'd be so rare that it happens, you'd probably be getting a call from the school board association, probably some of the state department, before they actually finish the meeting. It'd be like the Port Nicholas County superintendent didn't know he was fired until they announced it at the morning. Yeah, but you make the point, the school board association has a major role, as you know, in providing training. And failure without good cause to attend these things can be cause for someone to file a petition to remove you from office. It used to be that in the 4th year of your term, you had to get all your training done by January 1st. The other 3 years, it's by June 30th. They got rid of that to this extent. They said, if you're not seeking reelection, you don't even have to meet your training requirements in the 4th year. If you are seeking reelection, you have till June 30th to do it. They got rid of that January 1 deadline. They've added some members of the legislature as ex officio members of the committee that determines what trainings will be approved. And then in another bill, remember last year they said that if a board wanted to, it could raise board members' pay per meeting to $260. What'd you all do?
Our policy is a state statute. Doesn't go into effect
Effective
until
July 1 of
2026. So everybody would do it.
Because of that, the legislature, and the reason it was a problem was the Ethics Commission said you couldn't vote for a pay raise and then get that money in a meeting. The legislature says, well, you don't have to vote for a pay raise. Your pay is $260 a meeting. So they took care of that ethical problem that was there.
Now, that one started when,
26.
26.
You know, whatever it says.
Our policy, I believe, says July 1 of 2026.
But this could supersede that because this now says your
So it
meeting.
could be July 1 or.
Well, what's the effective date on that? Not the beginning of the handout on that. We put the effective date on the bill.
July 3rd
Okay.
this year.
July.
July 3rd.
Now, what they do say is you can pay less if you vote to pay less. So they're making the decision for you, but if you want to be paid less, you can vote to be paid less, but then there's still an ethics problem there. You're voting for your pay. So you say, I'm taking a pay cut. Ethics Commission say, we don't care. You're voting on something to do with your pay. You want to get it during this term of office? I think that's what they'd say. This is taking care of that. You can go to 260.
So do we need to repeal our current policy that says effective July 1 of 2026?
Yeah, because it violates the statute.
We just need to change it effective July 3rd.
July 3rd.
Based upon this.
Yep.
Okay, there was a bill here that would have said people on the state board can't be involved in party politics. That got vetoed by the governor. This one, I'll just briefly, you can read the details, says that if the State Board of Education passes a policy, it cannot take effect until it's gone to the legislature for them to review, for the legislature to amend, for the legislature to say, this isn't going to become a policy. Every single policy passed by the board, except in an emergency. And then you'll see on some of the slides, even in an emergency, as soon as you file it, it takes effect, they then go through the review process and they can still find that it needs to be amended or it's going to be repealed. So the state board voted last week to file a lawsuit about this. There was a lawsuit back in the 80s where the same thing happened, and our Supreme Court said the legislature cannot have a veto power over State Board of Education policies, that the Constitution gives the State Board of Education a role in operating the schools. And, the voters, there was an amendment proposed to amend our Constitution several years ago that would have said that the legislature has final say on state board policies, and the voters did not approve that amendment. So this litigation, the board voted last week, the state board, to challenge this in court.
Where do you think that will end?
Well, ordinarily, courts follow their precedents on important issues like that. I would expect that's what they will do here. They'll say, hey, we've already been into this, and the voters rejected it. But never say never.
Yeah.
Sometimes lawsuits are won or lost on points that nobody ever thought of. So,
Because otherwise, there would be no need for a state board of education.
well, that's the argument. Yeah. And of all things, the argument years ago was over the C rule for participation in athletics. The state board adopted the policy, and the legislature didn't like it, and so they fought about it. Everything, well, not everything, but a lot of important education rulings come down into the one thing that's the most important thing in the school system, that's athletics, right? That issue was about proceeding. This allows the state auditor, the legislature created its own auditor's office. So you have an auditor that comes in and does your annual financial audits. This is different. They have what they call the legislative auditor. When the legislature wants something investigated and report back to the legislature so they can take some action, they have this office of the legislative auditor, and they say, you go out there and look into XYZ, maybe it's about daycare centers or something. Well, they have now commanded the legislative auditor to do a performance audit of the State Department of Education by the legislature. And it's not just financial. It's like, are their meetings efficient? Are they staffed efficiently? Performance audit, it's called. And this law doesn't direct them to do that to any counties, but says that the legislative auditor can perform the same sorts of audits of individual county school systems. So we'll see how that works out. This is another curious one. This says the state superintendent is required to annually report to the legislature every county board of education that violated any state board policies in the past year. And if the county is found in violation by the state superintendent, it directs the state superintendent to develop a proper plan to get back into compliance. And but give them community details, what that means. And if the county board doesn't follow the plan and get into compliance and follow the state board policy, then this says school aid funding may be cut off. Doesn't say who does it, when they do it, but that's the axe they're holding over counties' heads. So there's a real push on here to move the center of gravity on important things about school systems to the legislature. And once those policies are passed, to be sure that the boards are following them. I'm not, we could spend all day on these. We did when we were at the School Board Association. This is the bill that the governor championed and passed that defines men and defines women. So you can read what the definitions are. Remember on the news last year, there was some government person was embarrassed under oath by Congress. The Congressman says, can you define what a woman is? Well, you can't even define what a woman is. What's a man? When you start thinking about it, it's kind of hard. So here they finally defined, you're either a man or a woman based on what your biological sex was when you were born. That's what this law says. We don't recognize anything else. A female is an individual who naturally has had, will have, through the course of a normal development, or would have, but for developmental anomaly, genetic anomaly, or accident, the reproductive system that at some point produces, transports, and utilizes ova for fertilization. Wouldn't that have bowled them over if that person testifying just recited that definition, just boom, boom, boom. And a man is an individual who naturally has had, will have, through the course of normal development, or would have, but for some developmental anomaly, genetic anomaly, or accident, the reproductive system that at some point produces, transports, and utilizes sperm for fertilization. But this does say that we always look at what the birth certificate said. And it has to be a birth certificate that was given near the time of birth. It can't be one today. There's been amended to show some other gender on it. And here's the consequences for the public schools. This says that every public school system must designate any restrooms and changing areas that are designed for more than one person at the end of a time as either for the use of females, as so defined, or males. So this is the transgender issue coming forward. And you must also provide a reasonable accommodation to a person who's unable to use one of these multiple occupancy restrooms or changing areas designated for their sex. So if you have a transgender child, for example, they either have to use the female restroom if they were born as a female, or the male if they were born as a male, if we're talking about restrooms where other people can come in. Or we must give them some reasonable accommodation if they don't feel comfortable doing that. So that may be the faculty restroom or some other restroom. I was at Huntington High School this weekend for an event, and they have all single person bathrooms. And 2 people can't go into them. So even though they call them men or women, this law wouldn't have governed that because there wouldn't be another person in the room when you were there. They do the same thing with changing areas, male, female, or accommodation. And then they have rules about overnight trips. And if you have an overnight trip involving students, you have to ensure that a girl, defined the way they're defining it by what you were at birth. If they share a room, they share it only with other girls. And if they're a boy, they share it only with other boys. But there's an exception if you're from the same family. A brother and sister can use the same quarters.
What they didn't think about were same-sex couples in the same room.
Yeah. And they
You
do,
had 2 girlfriends in a room, 2 boyfriends in a room.
Yeah.
Now what?
well, they haven't gotten there yet. We're not allowed to, and nobody is allowed to examine, and this has some meaning for you all, I know. Nobody's permitted to examine the body of the child to determine if they're a man or a woman. We have to go back to a certificate that was issued at the time or near the time of their birth. And if the school district is required by the government or anyone else to make reports based on the number of girls that do X, Y, Z or boys, we have to respond counting boys as boys only if that's what their certificate said when they were born, and girls as girls only if their certificate said that before. Senate Bill 474 ends the DEI. And I've learned that very few people can tell you what DEI is. They have their opinion, but it's not the same thing that's in this bill. This is, it says that the purpose is to ensure that various agencies, including school boards, treat individuals as equals under the law with respect to recruitment, hiring, promotion, and training. And it eliminates diversity, equity, and inclusion programs, trainings, activities, offices, and officers from the schools. Here's what they mean in this law by DEI. Any action, attempt, or effort to influence hiring or employment practices with respect to race, color, sex, ethnicity, or national origin, other than through the use of colorblind and sex-neutral hiring processes in accordance with the laws. It's any effort to promote or provide special benefits to individuals on the basis of race, color, ethnicity, or national origin. It's any effort to promote policies or procedures implemented in reference to those things. It's to prohibit trainings, programs, or activities that are implemented in reference to race, color, ethnicity, or national origin, other than trainings, the sole purpose of which is to comply with any federal or state laws that require the trainings, like we have required multicultural education by law in the public schools. No school board may establish or maintain an office or division or other unit by any name whose purpose in whole or in part is promotion of DEI. You can't hire or assign an employee or contract with a third party to promote DEI, and you can't compel anybody to practice DEI. You can't give preference on the basis of DEI to an applicant for employment, an employee, or a participant in any function. And you could read the rest of it. They have a set of rules here that really bring it down to the granular level.
Are there school boards that have DEI office?
Well, by name, there's one I know of, and they've changed the name of it and dispersed the functions. There's a complaint procedure that parents can follow here if they feel that this has been violated, and goes up to the state superintendent of schools. Every year, your superintendent's going to have to report to the state superintendent how many complaints were filed in the school system by people claiming this DEI policy was violated and what happened to those complaints. And the state superintendent's to compile all 55 complaints or reports and give it to the legislature. So you can read the rest of that. I don't mean to skip over important things, but time's wasted. Here's House Bill 2129, creates a Parents' Bill of Rights. And this isn't just a natural parent. It can be an adoptive parent, a legal guardian. And it says that you may not infringe on the fundamental rights of a parent to direct the upbringing, education, health care, thinking immunizations, and mental health of his or her minor child without demonstrating that such action is reasonable and necessary to achieve a compelling state interest, and that such action is narrowly tailored and is not otherwise served by a less restrictive means. And then they tell us what it means. Parents reserve the right to direct the education and care of their minor children, to direct the upbringing and moral or religious training of their child. The right to apply to enroll his or her minor child in a public school or an alternative. The right to access and review all school records relating to their child. The right to make healthcare decisions. And we can't abridge those rights. And that's like the 10 Commandments. It's hard to think of all the things that could happen to somebody claims that we have violated the parental rights. But I'm sure we'll hear about it. There are exceptions, of course. Parents can't abuse or neglect their children and get away with it. Those laws are still in place. This doesn't condone parents taking action that would end their child's life. And it doesn't keep a court from entering an order that directs to the student be educated or treated in a particular way. And this bill, House Bill 2402, gives a parent, guardian, foster parent, or kinship placement. That's when the child goes to live with their aunt or uncle or another relative or grandparent. We cannot deny them access to the child's health records if they're a minor, unless a court blocks the access, the child has graduated, the child's emancipated, or the child's married. And we cannot make any of those people produce signed statements, say, from the child saying it's okay to release the medical records to grandma. They have an absolute right to those records, and we can't have a permission slip in between. On health and safety, I'll just draw your attention to some things you might want to read more about. This is the bill that takes the dyes out, the foods out of the dyes. It has some exceptions in it for fundraising events that take place often away from school premises. They can sell goods that have the banned dyes. There's also an exception for a school fundraising event that occurs at least half an hour after the end of the school day. Those nachos just wouldn't be good without that orange stuff. That's right. That's right. Be aware that whatever mapping you have for security purposes of your buildings is going to have to be redone. This bill has 2 dozen requirements that mapping now has to meet for every school. It also has to be done in conjunction with the emergency services people. We have to use a format that works with the apps that emergency services uses. So they don't have to enter all this stuff. You can just set it for them and boom, it's in their app. And the state has appropriated a little money for this. They will not give you more than $4,500 per school to do the mapping. I understand the appropriation is like $2 million, which doesn't cover $4,500 per school. I also have heard that the average cost of a map is $7,500 per school. So this is going to be an unfunded mandate. And this one I want to just mention because I've had several school districts that want to have undercover police officers in their schools. And some have already done that. They've hired them as their employees. There's one school district if you know the people at the school, you'd say, who's that van out on the playground? I've never seen him before. And you go up and say, are you supposed to be a substitute teacher? No, he's really an undercover police officer with a weapon.
Why?
I like that.
Hmm?
They can tell you that, they can say they're a substitute teacher, or
That's what they're doing
Why?
in one county, just to have protection against a shooter that comes in and not realize that this is like the people on the airplanes.
Well, it beats having teachers carry weapons.
Yeah.
Yeah,
Yeah. Now, think about what I said before. You're only allowed to do things that the law authorizes you to do. I was hard pressed when one of the counties called me and said, are we allowed to do this? I said, I can't find a law that authorizes you to have these people with, it's a felony to have a deadly weapon on school premises unless you meet certain requirements, which I don't think this does. Well, they took care of that here. They don't require you to do this, but they gave you 3 options if you want to bolster security in your schools. And you can read the details, but the first one is to have these people as your own employees. And there are all kinds of requirements they have to meet, but they are allowed then to possess a weapon on school premises if the county board agrees. You don't announce who they are. You don't have to disclose their names to the public, but they're your employees. They get contracts, they get benefits, they get personal leave, just like a regular employee would. Now, they have to be certified by Homeland Security in Charleston as being capable of doing this, and they have to be able to show they've had the proper trainings. Even if they're former law enforcement, they have to continue their trainings. There's special trainings they're going to be required to get for dealing with special ed kids and crises in the school environment and so forth. So these are called school security officers, and they're actual employees, or school safety officers. They're actual employees of the school district. And they don't have arrest powers, but they have detention powers. They can hold somebody while the police are called to come. And there's insurance requirements, and there's not a uniform requirement, so I think they can be plain clothes. They don't have to have weapons, but if the board decides that they can have weapons, then that's fine. The board pays all the costs of any expenses that they incur, like for their weapons, or I don't know, I assume that might cover the training they have to get periodically too. I don't know, but that probably will be the case if they're your employee and then they have to have training. If there's a training they have to get before they become an employee, then that's on them.
So this was, in a sense, it could be replacing the PRO.
Sort of, although your pro officers are law enforcement officers, so they can arrest or.
No, what I'm saying
Yeah.
is, why would you want to take the full cost on that?
Yeah.
If we're having some of the municipalities that are chipping in some, I mean, that doesn't make sense, and it's uniform and
Yeah.
legal.
And I think the one county I was dealing with felt that they needed the undercover piece of it because of some things that have happened in their school system. The second thing you can do is you can contract with somebody, not as an employee, but as a contractor. They call them West Virginia Guardians. So these have to be former law enforcement or military law enforcement. They have to be certified by your sheriff, who has to vouch for their training and their skills, and special training they have to get. Their criminal background checks, there are all kinds of requirements you can read about here. And when we get that publication out in a couple of weeks, it'll have even more in it. These people have to wear, it says, doesn't say a uniform, but it says special attire, which I think probably means something that everybody would recognize them as, like your pro officer, you want people to see what you have. So these people have to have some distinctive attire that they wear. They too have detention authority, but not arrest authority. But they don't have benefits. They don't have the due process rights of reductions in force or bumping people or workers' compensation coverage or PEIA or retirement. They were contracted individuals. And the third choice is to enter into a contract with a private security guard firm. And the law defines what a security guard firm is, and it's got to meet, obviously, a bunch of requirements. The person who owns that company, it can't be an ESC, which I think was an idea that the ESCs would hire these people and then send them to you. The ESC is not a security guard firm. So it has to be a security guard firm, and you can contract with that firm rather than with the individuals and say, we'd like you to supply 3 security officers for yeah, security officers to the school. There's no requirement of a uniform in here, although many security guard firms require their people to have uniforms. They too have to go through extensive background checks and training and so forth. So you can have an employee, you can have a person who has an independent contract with you, contracted service, or you can contract with a security guard firm, and you don't have to do any of those things. But they did open the door for school districts that are interested in something like that.
Personnel you could hire. You could have odd guardians, and one security firm you hire totally different people.
That's a good point. I don't see any prohibition against that in there. You could exercise all three options depending on.
Well, that's kind of what I was wondering, right? I mean, are they limiting the amount of people you can have in one school?
So this bill this is the one about kicking kids out of the classroom. I'll let you read the slides on your own because this is the most time-consuming bill. But essentially, right now, it's already been the law that if a child engages in certain misconduct in any classroom, the teacher can exclude them. They go to the principal's office. And they can't come back to the classroom until the principal says they can. And if the principal imposes any discipline, when he sends them back, he's going to tell the teacher what they did. If the student does the same thing in the same school year, I mean, it's excluded from that same classroom a second time in the school year, and before they can come back, the principal and the teacher, and now the parents under this law have to meet and decide on what we're going to do in the classroom after one child comes back again to try to prevent this. So that's new that the parents involved in that. And then if the child's excluded yet again, then we end up with sending them to a behavior center, doing functional behavior assessments, functional behavior plans. There's an unrealistic timeline for all that stuff. They seem to think you can do an FBA in 2 days. I just can't get into all the inconsistencies, but they're all spelled out there and you'll see them better in the thing we send you. This is something that your administrators really need to get a grip on because there will be some teachers that believe the media, like you boot them out the door, police have to take them home, I never see them again. And there'll be other people who want to do the right thing and they'll say, well, we don't have a behavioral health center, what do we do? And it's got provisions in the law, you got to partner with another county and create those services or enter into a contract with a firm. But it's very complicated, I just don't have the time, we don't have the time here to see if we come into it.
Hypothetically, all right, in some of the elementary schools, children change classes, okay? So if poor old Johnny misbehaves in the class and he's taken out and put, with the principal, then he's sent back and he's told not to, he can have no more violation of that rule, okay? That's in that classroom.
Right.
What happens if he goes to another classroom and the same incident occurs? Is it separate or you put the two
The
together?
existing law is classroom by classroom and bus. And what they've done is they've added some provisions for certain types of behavior that exclude the child from the school, not just the classroom, it's the school, so it wouldn't matter what classroom you occur in. That's just part of the complexities of this thing. We're trying to wrap our arms around it, and the State Department's trying to get some advice out. But when you read the slides, if you're interested in it, and when you read what we sent out in 2 weeks, I think 6 pages of our summary addresses some of the problems that weren't addressed yet.
What do they define as an alternative learning accommodation?
That's
We don't know.
no.
So would that be like our fee?
Excuse me?
Well, it goes into effect July 2nd. It could be, I think, our second chance. I mean, if we
It could be.
remove
Oh, okay.
we have a type of in-school suspension in all of our buildings right now, which I think would cover that.
Yeah, we really need to bore into, each
Yeah,
county's
we
going to
don't
have to
have an
bore into
off-site
the requirements.
Alternative center, and usually we have already things in place, I think.
And it's a fertile area for litigation with parents
Yeah.
and organizations that advocate for kids. You can read about getting rid of work permits. You already have a law that required any of your schools to have athletic programs, to have cardiac arrest plans, and parents had to get a copy of that plan before their child could participate in athletics. If the child's failing, they couldn't participate again until certain things happened. They've expanded that now. Every school in your district has to have its own cardiac arrest, or call arrest. It's not a criminal arrest, but your heart stops. Cardiac arrest plan, whether you have athletics or not. But they make it very clear, it's not a county policy, it's a school by school policy, and in every instance is developed with input from emergency services. And do you have rimfire rifles or compressed air rifle teams? Some schools do, and that's a deadly weapon. This allows them to have it at school or on the bus, as long as it's locked up on the bus in a special compartment or locked up at school where no one can get to it if they're bringing it for practice or for competitions. This increases the penalties for people who commit child abuse or neglect. They get more prison time. This is a bill that bans cell phones. Do you all enacted a cell phone policy?
We have had one.
Yeah, you need to go back through it now and compare it to what the law requires. Most counties that have passed one, most of your policy will be good, but there are certain things you have to have in it now. You got to make it clear it applies to laptops and all manner of electronic devices that kids own and bring to school. You have to say whether the devices will or will not be permitted on school property, even on non-instructional time. If you decide that they'll be allowed on property, your policy has to include a procedure for storing the devices. You have to specify where and how they'll be stored during the instructional day. There's an exception for kids with a documented medical need or licensed healthcare need to have their device with them, but it has to be a very specific exception, what class, for what purpose. So we know people aren't just using that as a way to get around the policy. You have to, here's a list of things. You have to have penalties for a first offense, second offense, subsequent offenses. You have to provide for confiscation of the device or require the student's parent to retrieve it. Your policy has to prohibit a person from possessing any device. If they previously misused a device on school premises, they're banned. You have to, if a person's banned from having a device on school property because of prior misuse, you have to offer a conference to their parents. All of this information policy has to say it's all going to be entered in LEVIS. And then you have to make reasonable efforts to let people know about this policy. And you have to develop ways that parents can get information to their kids at school. They can't contact them on a cell phone or other electronic device. And they give some examples here of specific times when they are allowed to use their devices, like lunchtime or whatever. Or tell them to call the office staff to give information to the student. What happened when I went to school, you really got a message from home. You knew it was a really big one if you got it that way. Or any other strategy that's designed to address parents' concerns that now they're not going to be able to communicate with their child. There's a law here about the testing schedule for kids, about attendance. You'll see some exceptions for college visits. Under discipline, they've modified a bunch of the pornography and sex crimes to include AI images of people, fake people, or altered images if people were trying to blackmail somebody with those or just expose them through those. That has the same penalties as if you had an actual photograph of them or an actual video. And in instruction, we're not allowed to instruct kids about sexual orientation. And this makes the same distinction between biological sex and gender identity that we did before. And we cannot provide instruction related to sexual orientation with two exceptions. The teacher can respond to student questions in class about sexual orientation, or if you have a part of a curriculum established in a dual enrollment or AP class that refers to orientation or the identity of historic persons or groups to provide necessary context to a topic of instruction. So, Abraham Lincoln was a transgender person, they might say. They could talk about that. Why would you be talking about
historical figures, sexual orientation, I don't know, into the school.
Who's the FBI director? Board trustee.
Now, if a student,
J.W.
if a student indicates to any service or professional employee that they intend to change their gender identity, that employee must tell a school administrator, who must contact the parents. Say, the janitor tells me that your son told him that he would rather be a girl. And employees are to be disciplined if they don't report that information to the administrator, or if the administrator doesn't report that information to the parent. I'm not sure how often that happens, but there's a complaint procedure. You have to have that half-credit personal finance course to graduate now. You can take it in 8th, 9th, or 10th grade, and under this law, instead of just junior or senior year. And if you've already taken it in one of those years, then we have to treat you as having satisfied the requirement, even though until now you could only take it, we're supposed to satisfy it by taking it in 11th and 12th grade. They have a new computer science requirement we're going to have to implement for the 2027-28 school year. It's a full credit. And it's really interesting. They say it means the study of computers, programming, and algorithms, including their principles, hardware and software designs, implementation. It's not the study of everyday uses of computers and computer applications such as keyboarding or word processing or digital literacy or accessing the internet. So this is on the technical side of computer science. Every student to graduate will have to have a credit in somewhere in grades 8 through 12. Oh, by the way, the legislature says the course must be high quality. That's the language they use. I don't know what that means. Aren't all our courses high quality?
Ready?
Yeah. Now, here's real quick on personnel. You use retired teachers as substitutes, I assume, in areas of critical need. You get state board permission to do that. If they're if we have a vacant teacher's position, we've been posting and no one comes, we can use a retired teacher in that as a substitute if we don't have any certified substitutes. Until now, it said that while they're in that job, we have to post it every week, trying to get some regular employee there. This says, no, just you have to report, you have to post at the beginning of the school year and midway. And otherwise, you can leave the person in that assignment.
So they could half a year, or, and they're still off field, and they can complete the full year.
Yeah, you don't have to post it, you put a regular person in. And you can, it still has to be an electronic posting, but it's just beginning of the year and mid-year. Same thing for retired bus operators who are using as critical needs substitutes. If one of those is substituting in a vacant position that we've not been able to fill, then we don't have to continually post it. We just do it at the beginning of the year and mid-year. Full-time interventionists, when they passed the law about having an aide in grades 1, 2, and 3 classrooms, they phased it in. They said you can use an aide or a paraprofessional or an ECAT or an interventionist. Of course, an interventionist is a professional, costs more, we don't get extra money for that. They wanted to be sure if we have an interventionist that we don't stretch them too thin. So you'll see here, an interventionist can be assigned to up to 2 second or third grade classrooms at the same time. So that will satisfy the requirement of having an aide, an ECAT, or a paraprofessional in each of those 2 classrooms at second or third grade. That option isn't available for kindergarten and first grade classrooms. In K and first grade, you have to have if you're using interventionists, they have to be full-time and they have to be assigned to just one classroom. At second and third grade, if you have a part-time interventionist, they can do one classroom and that satisfies the requirement even though they're only part-time.
Are we gonna be able to find part-time ones though, wouldn't have full-time work?
You always have some that want to be part-time.
There's
But
more
we're looking at it
requests
now.
than ever.
It's actually cost effective to go the professional route. in our third grades right now. The share number. So we're, you know, we have ETAs clear up through second grade, so we are looking on our third grade. Schools are preferring it.
We had already turned our microscope onto this bill when I prepared the slideshow, found something that nobody had told me was in here. I didn't see it anywhere. I hope you'll all be surprised to see this. Before December 31st, principals, appropriate central office personnel, superintendents, and county board members must receive in-person training on IDEA and its regulations and the State Board Special Ed Policy 2419 and its regulations. And every time those federal or state board regulations are changed, all those people, including county board members, must receive in-person training. So it's not video training, it's in person. And when somebody is newly brought on as a county board member or an appropriate central office personnel or a public school principal, they have to get the training. Now, the training has to include everything on this page, which has to do with all the different areas of special ed, including teaching them about what organizations are available to help parents with special education complaints and how to put parents in touch with those organizations, and about the rights of teachers to advocate for special ed students without being disciplined by the school board. This is the one that caught my eye that I hadn't heard about. Each principal, this is a separate requirement, each principal and county board members must inform teachers in person of their rights, including but not limited to the documentation process within a 45-day grading period for teachers, the rights of teachers when it comes to informing parents about local advocates who can come in or can come to the IEP meeting, about the protection methods in place for teachers who advocate for student placement, and about all the teacher protections and rights set forth in the West Virginia Code related to special ed. But it does say each principal and county board members must in person inform all teachers of these things.
It kind of contradicts this, doesn't it?
It's outside of anything we've ever seen before.
But it's not even rights, it's,
No, I mean, it's a contradiction of what.
yeah.
Our first.
I mean, somebody,
Yes.
you might wonder whether somebody is upset that their school board members don't seem to know about this. So we're not only going to make them sit through that first training we're talking about, we're going to make them help conduct this training. And maybe the thought is that if the county board members are there, when the principal is explaining that the employees will say, well, this must be serious because the board members are saying it's okay for us to tell people about advocacy organizations and the rights of teachers. I know one county is on a CE day is going to have an all teachers meeting and call a special meeting of the Board of Education for that day in the same room. And they're all going to be in the auditorium, and the principal's going to get up and tell everybody about that. The board members are going to nod their heads, and everybody goes home. And
Well, we could create a choral reading and take turns.
you can do a little skit,
Yeah.
the parts of the parents. But that's the first time I've ever seen that, where in addition to telling us what we have to teach, now they're telling us who's going to teach it besides certified educators. You are.
Like for board members, that could be part of the fall conference, I would think. Could they not put that in as one of the priorities that?
Well, it's something that this, you have to be in the room when the teachers are taught.
Do all the board members? do
It
we
just,
get-
it just says, and county board members. I wouldn't want to be a board member who didn't go and have somebody.
Yeah.
some
I think he's
zealous
talking
person.
about the in-person training.
Oh, the
Yeah,
in-person training, the first one?
Yeah.
Yeah, the first one I think could happen at that conference.
That conference, and then the second one take place. when-
Yeah, I see what you're saying now. Yeah, that first training, you're being trained in that one. The second one, they have you training.
Train the trainer.
Yeah.
Okay.
Then they've added some things that have to happen at every IEP meeting, but they didn't require county board members to come to them.
But they're always looking for new subjects at the board members' conference. I would think that would be one of the.
Now, when a new bill is introduced in the legislature, there's in the clerk's office down there, someone just gives it a name so that in the future, they know what they're talking about. It's hard to remember the numbers, House Bill 3209. That name is not part of the law. The good thing, this one says to provide at least one counselor for every 250 students in the public schools. But when you read the bill, it says, beginning August 1, we have to employ 2 school counselors to each 1,000 students in that enrollment. So that's 1 to 500 instead of 1 to 250. And they also say you're allowed to follow the ratios of 1 counselor to every 400 to 450 students in elementary and middle school, and 1 counselor to every 250 to 300 students in high school. So you can either do the 2 counselors for 1,000 students, or you can do those ratios down below for elementary, middle, and high school. There was no extra money put into the formula.
I was going to say, is there money behind that?
No.
It's gonna-
You can read about the CDLs that people lost and getting them back. Your cooks and custodians no longer have to have a high school diploma. Getting harder and harder, I guess, to find people.
I guess the question is when they bid on an aide job out of a cook's position, we can still say they have to have a high school.
That's a good question. Yeah, I think, I
Well,
thought about that. That's a good point.
But it just says cooks and custodians, it doesn't say aides.
But I'm saying though, they'll move, they'll try to bid, and I think we can look to see.
Yeah.
Last year, they exempted bus operators from the, so if you come in as a cook without a high school diploma, you could be a bus operator or you could be a custodian, but if you don't get your GED or your high school equivalency, you're right. I would say on the face of it, you can't get one of these other jobs.
Hard for an aide.
Yeah.
That's what we're thinking. But
And
they
then-
do move,
And
yeah.
just know your business office, your finance office is dealing with this, but there are some new rules about contracting for construction projects. We have to follow the statutory rules for that now when the project cost exceeds $50,000 instead of $25,000. Bids have to be valid for 90 days from the date of the bid opening, instead of what they are now, which I think is either 30 or 60, I forget. And they've changed the rules a little bit about how you can negotiate with the low bidder, even though they're above your budget, to try to get them revenue to a level where you can do a deal. They've cleaned that up a little bit, and they give you 60 days to try to arrive in an arrangement with them instead of 30 days. Then there's a whole wing of this statute that has to do with what they call construction management at-risk contracts and how you bid those. And these are projects that cost over $20 million. And basically, you're just saying, we want to hire a at-risk contract manager. And it's explained that person is really, and they did, they're saying, I will deliver to you the project that you want built at the cost that you've given me, and or that I take, and I will take care of the contracting. I'll be involved in the architect and the engineers, and it's like one person is doing all that stuff and just turnkey things. I think that's what they mean. So we'll see if that takes off. But it puts all the onus of compliance and everything on them. And there's controversy about this bill. You can read about it. There are taxes that come in from these large data centers, high-impact data centers that want to build around the state. 100% of the property tax is not coming to the county, those counties. Only 30% of the real estate taxes, the property taxes that come in on those projects will come to the county and therefore be part of your excess levy or whatever. The rest is going 50% to a state fund to reduce personal income taxes, 10% to all the other counties on a per capita basis. And that's very controversial. Originally, there was no money coming back to the counties, and they're getting 30% now, but that will impact your excess levy if you had a high-impact data center in your county.
The commissioners, that one pay for it.
Yeah. And this sounds good, but it really doesn't affect you. This requires state agencies to pay their bills within 45 days or something like that. It'd affect you, I guess, if they owed you money as a school board.
We're already on that one.
Yeah,
But it doesn't apply to federal pass-through funds that come from the federal government through the State Department to you. The State Department isn't under that 45-day rule for those. And then the magistrates now can hear cases where the amount in question is up to $20,000 instead of just 10. And regrettably, we have some school lunch bills and other things that get into that range. Then there's a bunch of things here about charter schools. Just the story here is they're making it easier and easier for charter schools and private parochial schools to operate. You can read the bullet points in our summary. I'll not take time for that. I will mention, though, that they do authorize the establishment of high-risk charter schools. And this is where at least 70% of their enrollment must be high-risk students. And they define that as students who've been expelled, students who've been suspended more than 10 days in a school year, wards or dependents of the state, recovered dropouts, students who are habitually truant, students who are credit deficient, students who have a high level transiency, who move around too much, foster youth, homeless youth, and students who need greater flexibility in scheduling. So the fact that they put this in makes me think someone's got an idea for this. It's so specific. It's like you're authorizing it, because ordinarily you have to have a lottery and let anybody come to your charter school.
Where there's going to be 5 of these programs for people right around the state. If there's a funding,
who's gonna teach?
what? That's just
There was some talk, I never came to anything, that when Alderson Rock was closed, that would be a residential school for people like this. And they allow students in Christian schools at the elementary and middle school level to participate in county level sport tournaments. And then the last bill, public schools have to display in a conspicuous location accessible to the public in a common area of the main building, a durable poster or framed copy of the United States motto, "In God We Trust." And we don't like,
Be in English.
it doesn't say
It
that.
doesn't say.
It does say "In God We Trust." Maybe they would say maybe in English, or they would put something else on.
In God we trust, all others pay cash.
And not to micromanage or anything, it must be a minimum of 8.5 by 11 inches. It must contain a representation of the United States flag centered under the motto, and it must not depict any other words, images, or information. And best of all, no public funds can be used to produce this and frame it.
Wow, 8.5 by 11, that's in your face,
Yeah.
right there. You're gonna see that walking in the building.
That's a quick tour of legislation. If you're not already getting our newsletter, if you sign up now, you'll get it in 2 weeks. And again, we don't use that list or anything else, except to send you quarterly school law news. It's a good way to keep up to speed. And I think by the next time I see you all, we'll be in the School Board Association meeting with the new director. I think they have some arrangements. Yeah.
Yeah, there's an
Power.
email came out today.
They
They put
rejected
power
all the
back
applicants and Howard calls coming back.
And they voted it up till
And they're
December.
gonna have
Yeah,
elections.
December 30th.
December 3rd.
And he's agreed to come back for that time and left the door open that
He could go
he might
longer.
come back. You have to wonder whether he got out there and regretted it or.
That's what I'm
Yeah,
thinking.
He's a nice guy.
Guys, wasn't always here.
Yeah. Thank you for having me. It's
Thank you.
fun to be with
Thank
you.
you.
I appreciate it.
It's always, does my heart good to speak to people who are paying attention. You're not here because you have to be, or you're just wanting to. That's fine.
So can I ask you a question about the vaccination? Mandate the government for that?
Yeah.
How's that gonna work?
Are we?
Do we have to abide by it?
That's going to be resort.
It's gonna go to court.
And it's not going to be in times people already signed up for school. What we're telling people right now is we don't know what the ultimate resolution of it will be, but that it's kind of like the advice that the state superintendent put out there in the practice. Provisionally involves students, parents, they have the right to the health director. state level, saying we want this exemption. State health director is writing something saying we're not going to enforce the immunization law against these people. We'll get a copy of that. And those boards are now saying we're additionally enrolling your child in the schools and some of the resolution of the question.
We do similar things now where the parent will feel, and then they give them another
They get a release
waiver,
and then another
yes, and then they
release.
appeal again.
But right now,
If that's your-
a family moved here from another state that didn't have immunization laws. It's already the law in the state that have to predict. There was a kid who tried to come to Clay County 6 or 7 years ago, and his parents didn't have any immunization certificates. Somebody had trouble getting this, and so Clay County did not enroll the child. Of course, Florida judge traditionally enrolled the child for 6 months or something, if they didn't have the papers at that time, then they could unenroll them. Hopefully, we won't get to that point after we can make a decision.
We work with, we take, so, I mean, we have to come in, but the issue is when they know an exception for whatever reason, so it's not getting them the shots they gave them.
So that's the state's big thing, and the timing was really bad.
Yeah.
Thank you.
Thank you.
Appreciate it.
Thank you very much. It's good to see you.
Stay with us.
Somewhere down the trail. Yes.
Don't say in every classroom
No.
or in lobby.
No,
Was it every class building?
It's a common area building.
Okay.
So you're
Not
out.
really another common areas of buildings, we go to the cemetery, lobby, we go to the gym.
We were thinking, every classroom. Oh, my. A lot of science.
And we all know, as soon as that side goes up, all the bad drug use and bad stuff. Absolutely, behavioral stuff.
Behavior.
It'll be 100%. I think we should bring that.
Well,
You might get back to Charles and down
10
here.
years.
Uh-huh.
Still talking.
Yeah, but we can, though, I didn't.
It's been longer than that.
Maybe 12.
It's been a while. I remember that day. I remember that
You
day.
will go to all the art programs.
Yeah, we're still.
Oh, no, we gotta get somebody to donate a piece of paper.
Dora, I'm gonna leave these over here in case you wanna.
Because we can't, it has to be donated money, it can't be in school money, so we can't use school supplies. Somebody's gotta bring it in here now.
Yes, no, yeah, so I said, we're still.
Oh, sorry.
Yeah. Thank you, Howard, we appreciate it.
Thank you.
Thank you very much.
Thank you, guys. Thank you.
Safe trip home.
I'm listening to a podcast about World War I. I'll be sad when I get home.
We have to move to close.
Yeah, but, don't, do we report any comments on here? Do you want to have board member comments? Mr. Evans?
I thought it was an excellent presentation.
No comment.
Listen,
No, I'm good.
I have not even registered for this together.
It's very good.
There's a motion to adjourn.
I said,
Second,
You want to put second?
all those in favor say aye.
Aye.
No, they don't care.
Motion carries.
we might need it again.